Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw an eye and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Welcome to the afternoon session of our first case call of our new term. This afternoon we have a calendar case, Black versus Shafer.
Good afternoon, Courtney Jones on behalf of defendant appellant Anthony Shafer. I would like to reserve time for rebuttal if it pleases the court.
You have to manage your own time, but yes.
I'm going to briefly touch on the facts of this case to remind you of what we have here in front of us. The plaintiff appellee, Jessica, was shot in the leg by her boyfriend, Ian Gearhart, while she and Gearhart were social guests of Anthony Shafer's grandparents' home. Plaintiff, Gearhart, and some friends went to Shafer's grandparents' house earlier in the day to go swimming. And then later, the
Counsel,
girls...
I usually start out, sorry.
Oh, sure.
You have 5 minutes of uninterrupted time. We have read the briefs. I would suggest you get to the outcome determinative issues in the case.
Okay. This court asked us to address 6 issues. I'm going to touch on a few of them. With respect to whether or not Shafer owed plaintiff a duty in this case, as we set forth in our brief on appeal, Shafer did not owe plaintiff a duty. Shafer, if you recall, checked the weapon, pulled back the chamber to make sure there were no bullets in the chamber, pulled the trigger to confirm that it was not loaded and would not fire, gave it back to Gearhart to take a look at. Gearhart looked at it and put it back in the place where it was. Plaintiff is alleging that Shafer should have done more. Shafer secured the shotgun by making sure that there were no shells in the chamber and pulling the trigger to confirm that it was not loaded. Simply alleging that he should have done more is not sufficient under Michigan law. Second, we cited several cases that there is no duty regarding the storage of a gun, specifically Lolito versus Monroe and Bridges versus Parrish. With respect to the incident being foreseeable or unforeseeable, as it is our opinion, we say that Shafer could not have foreseen this incident. Gearhart did not play with the gun when he picked it up the first time. He did not aim it at anyone. He did not pretend to shoot someone. He did not cock it, and he simply looked at it and put it back. Hours later, after they had all went down to the lake to go swimming, Anthony Shafer is still swimming in the water, has no idea that plaintiff and Gearhart have left the lake, gone back to the garage. He could not have foreseen that they were going to leave the lake, go back to the garage, pick up where Gearhart was going to pick up the shotgun, rack a shell into the chamber, point it at plaintiff, and pull the trigger. There was no prior conduct by Gearhart that would have put Shafer on notice that he was going to do that. There's no evidence that plaintiff and Gearhart were having an argument or were somehow fighting, and he would have had any thoughts that he would have picked up the gun to shoot her purposefully either. And as I said, he had no knowledge that they even had left the lake and gone back to the garage. As far as he was concerned, they were all still swimming in the water. With respect to the criminal action, it's undisputed that Gearhart committed a criminal act in shooting the plaintiff. Third-party criminal acts are unforeseeable by nature. Plaintiff alleges that this rule only applies to intentional criminal acts and not negligent criminal acts. However, they cite no case law in support of their position in that. And we cite a case, Coolahan versus Stamper, which is cited on page 17 of our brief on appeal, which is actually an accidental shooting where they were playing with the gun beforehand and pretending to shoot people. And then after that, he accidentally shoots the plaintiff. The Coulihan court found there was no foreseeability, even though he was playing with the gun beforehand, before he shot him. In this case, Gearhart simply looked at it, put it back. Hours later, after they were swimming, and unbeknown to Shafer, they went back to the garage where he picked it up, racked a shell, and shot the plaintiff. There was no special relationship between the parties either. This case is unlike the special relationship cases that have been previously recognized in Michigan, and the rationale behind those is imposing a duty to protect based on control.
Well, you make a conclusory statement that there's no special relationship between the parties. I understand that common law, there's not traditionally been a special relationship as a function of the fact that person A induced a minor to use alcohol and person B was that minor. But why shouldn't there be some kind of special relationship in that context?
Well, in our case, Shafer says that he did not supply alcohol to the minor, that he did not give it to her to drink, and he did not see her consuming it.
But that's in dispute, is it not?
Plaintiff says that she was drinking it.
Assuming that that does describe the relationship that they had, why shouldn't there be a special relationship?
Because this is not like social host liability where you have a duty to, it was not, I guess I should say, it was not her drinking that caused this incident. Her drinking had nothing to do with causing this incident.
Well, her drinking may have caused her to go back with the shooter at a time when maybe that wouldn't have been the wisest thing to do, isn't that correct?
I guess it's possible
To
that
go
her
back from the
drinking
water to the garage, I think it was.
Yeah, the shooter was her boyfriend, so I'm assuming she would have felt comfortable going alone with him regardless of whether she was drinking or not.
Maybe not in the proximity of a weapon, however.
I do not see how her alcohol consumption had anything to do with the boyfriend picking up the gun, racking a shell, and shooting.
What world are we in? What legal framework are we in? Is this a premises case, or is it a simple negligence
It
case?
is our position that this is a premises case based on a condition on the premises and instrumentality on the premises.
You contend that the shotgun is an instrumentality of the land?
Yes, we have cited a couple cases where they have found guns and shooting to be instrumentalities of the land. Same with the lawnmower, found to be an instrumentality in the land.
Weren't those cases as much about how the owner of those personality tractors, persons, not real property, were operating them as they were a defect of the premises?
Well, in this case,
No, I'm asking. You've cited cases that talk about personal property as though it were an appurtenance of the land itself. And I'm questioning whether, if you look carefully at those cases, wasn't the gravamen the way the owner was operating those personal pieces of property than that they were actually a defect of the premises itself? I mean, I know they were using premises liability as a rubric, but I'm wondering if you look at what was happening in those cases, they were using a rubric that probably had less to do with what the analysis was about than negligence.
well, in the Coulihan versus Stamper case, that was the case that I was talking about where they had aimed a gun at him in an attempt to scare him and pulled the trigger as a joke, but accidentally shot him.
That doesn't sound like it's a defect of the premises, sounds like it's negligence, right?
Well, they framed it in premises liability and found that his defendant's failure, based on defendant's failure to protect him, they framed it in a premises liability theory in that case.
Yeah, I know they did. My question is that a proper framing?
I think regardless of either framework, you can't find a duty here owed on behalf of Shafer.
All right.
But isn't that perhaps the right prism through which to look at this case, not necessarily through premises liability, but simply through ordinary negligence?
I think whether you examine it under premises liability or ordinary negligence, you're going to come to the same conclusion that Shafer did not owe a duty to the plaintiff under either theory.
So does it actually matter to you? Do you care whether we write an opinion that finds that this sounds in negligence rather than premises liability?
I think that the case law shows that it would sound in premises liability. I think the allegations in plaintiff's complaint would show that it sounds in premises liability. However, I think under either theory, you're going to come to the same conclusion whether you say this is an ordinary negligence case or a premises liability case. I think the ultimate conclusion you will reach is that he did not owe a duty under either theory.
Could be the case that both theories apply, right?
I'm sorry, it could be the case. They argue that they allege both premises liability and negligence. I will say Anthony Shafer is not the premises owner. He is not the owner of the gun. The premises owners, William and Mary Shafer, his grandparents, were dismissed on summary disposition. There was not an appeal taken as to their motion for summary disposition on this case.
Counsel, though, he was, oh, I apologize. Did you have a question,
no,
Steve?
no,
Oh, okay. Counsel, he was the one who invited the people, though, correct?
He did invite them over.
Okay. And just following this through with the negligence issue and then looking at foreseeability, he invited them to the premises, and ultimately he was aware that the person who actually shot the young lady was quite interested in the weapon, was he not?
Well, I don't know if I would say quite interested in the weapon, but he was aware that he had picked up the weapon, looked at it, and put it back. He did not, the shooter did not play with it, did not aim at it, anyone did not try to cock it, did not do anything out of the ordinary other than pick it up, he said, and look at it, and then put it back.
So would it be your contention that ultimately it's absolutely, totally unforeseeable that if you have a weapon that's present at the time of people gathering for a party where you have alcohol, that it's your contention that it's completely unforeseeable that injury could result in the fact that a weapon is present, the weapon has been examined as we just discussed, and ultimately then used at a later point to injure another person who was present? I mean, your contention would be that's completely unforeseeable.
I would say based on the facts of this that it was. He did not, like as I said, he did not try to cock it. He didn't try to aim it at her. He didn't try to point it at her or try to pull the trigger. Anything of that nature that might lead the Mr. Shafer to believe that he was going to, at a later point in time, attempt to do those things. Further, the cases that we have cited, even the cases where the person was playing with the gun in the minutes before the shooting, they found it to still be unforeseeable.
Except he felt, I realize it's a double-edged sword. He had enough of a concern that he went and ultimately did examine the gun himself to make sure that there weren't any bullets in the cartridge. Is that correct? In the actual chamber, is that correct?
Yes, as soon as he saw Gearhart try to pick it up, that is when he made sure that it was not loaded and that it would not fire a shot before he let Gearhart take a look at it.
So he did have some concern about the fact that the weapon was present because he ultimately did do an examination of the weapon to determine if it had bullets in the chamber.
Well, I think because it was not his gun, I think that is what his concern was, to make sure that it was not loaded before he let him take a look at it.
But, counsel, it was, in fact, there were bullets still present in the weapon. Is that not correct?
The bullets were not in the chamber. They were in the reserve, so they had to be racked in order to be loaded into the chamber.
Correct. So I guess the question is that, we're just focusing on the issue of foreseeability. So as we look at foreseeability, the gentleman in question basically took the gun, examined the gun to make sure that there weren't any bullets in the chamber, but then still allowed, so he had enough concern to do that, but then he repositioned the gun back down in the place that it was at prior without taking out the other two bullets that were still left in the gun.
Correct.
Okay. And he ultimately, upon doing that, he didn't remove the gun from the premises. He didn't take the gun and put it in another place away from the people that were currently present.
Correct, he did not. And the case law that we have cited in our brief states that there is no duty to secure the gun. He did not have to lock it up. He did not have to move it to another location. I could cite the cases for you.
No, I'm familiar.
Oh, okay.
But I mean, you're doing a good job. I'm just asking you a series of questions just so I can have a better understanding of the situation. But let's go back to the issue where he again examined the gun, found that there weren't any bullets in the chamber, but still allowed for the bullets to remain in the weapon. But then, as you indicated with the cases that you cited, he ultimately, though, gave the gun back without the safety being attached to it. Is that not correct?
That is correct.
Okay, so the question I'm going to kind of go back to is that he had enough presence of mind that he was going to be concerned enough to take some action, but he didn't take the requisite action to prevent this accident from happening. Could you kind of walk me through that and help me understand your basic contention that this was a situation that was completely unforeseeable?
Sure. I think even had he put the safety on, this incident still could have happened because Gearhart could have taken the safety off before he racked the shell and pulled the trigger. There is no testimony about Gearhart's knowledge about guns, how familiar he is, how unfamiliar he is with weapons, because he did not appear and he was defaulted in the underlying or in the trial court level. With respect to your question about it being foreseeable, I guess I would say you were a collector of samurai swords.
Mm-hmm.
You had a samurai sword on a shelf in your house.
Mm-hmm.
I came to your house, I picked up your samurai sword, looked at it, put it back on the shelf. Is it then foreseeable for me to, hours later, come take your samurai sword and pretend to be a Ninja Turtle and, I'm sorry, I have kids, a Ninja Turtle and slice someone's hand open? I'm not sure that...
I appreciate the comparison, but I want to follow up on that comparison, and I
sure.
appreciate the exercise. Would you find that there's a distinction between a samurai sword and a loaded weapon, a loaded gun?
I would say that they both can cause injury to one another, and unloaded, there being no bullets in the chamber, without taking an affirmative action to load it by racking it, I would say that there was no distinction between the two. They could both harm someone, but they require an affirmative action to harm someone.
Any other questions? Then you may reserve the remainder of your time.
Okay, thank you.
Good afternoon. May it please the court. Steve Hicks on behalf of the plaintiff appellee, Jessica Bittner, and her next friend, Bonnie Black. In the order that the granted leave in this case, the court asked 6 legal questions, quite a few questions, and I want to get to those questions. They run the gamut from pretty much everything you could have in a negligence case: duty, breach, causation. But before I do that, I feel that I do need to discuss the facts just a little bit so that there's some clarity that the trial court didn't have and that the Court of Appeals evidently didn't have either. The Court of Appeals was correct in holding that this is an ordinary negligence claim, and they found that there was a reasonable argument, or reasonable jurors could find that there was a breach of duty as well. And in doing that, they focused on the defendant's acts. Basically, it's very simple to establish a common law duty. I mean, go back as far as Clark versus Dahlman when the court said, and this is a quote, "Every person engaged in the prosecution of an undertaking has an obligation to use due care, or to so govern his or her actions as not to unreasonably endanger the person or property of others." This court has affirmed that proposition in many different fact settings, in many different cases in the last few years. But specifically in this case, the facts are very important. First of all, if I could just say what happened here. We do know what happened here because Anthony Shafer testified, the defendant testified in his deposition that Gearhart, the shooter, told him this. He explained to me that he picked up the gun, cocked it, and he tried to cock it again, and the gun discharged. He wasn't able to cock it again because after cocking it the first time, there's a bullet in the chamber. So he's putting pressure on this pistol grip shotgun, and it discharged. So that's what happened. The focus of my argument, though, especially with regard to the duty element, is really on what the defendant did and what the defendant knew. And this has been alluded to already, I think, in Justice Bernstein's questioning. There's basically, effectively, a demonstration by Shafer to those in the room that this weapon is safe, based on what he did. What exactly did he do? Here's what he said. Ian, the shooter, went to go pick it up, meaning the gun. I grabbed it out of his hand, made sure there was nothing in the chamber, put the slide back, pulled the trigger, and then I handed him the firearm. That's important because of the second thing, what he knew. This question was asked. At the time that you handed Ian the gun, you were aware there were bullets in the gun, correct? And by that, the questioner meant not the chamber, but in the magazine. To that, he answers, correct. So what happened here is you've got an undertaking by Defendant Shafer. His affirmative acts in taking that weapon out of Gearhart's hand, probably the right instinct at the moment to do that, and then pulling back the slide, which is the pump, looking inside at the chamber and seeing, oh, okay, there's no bullet in there, and then turning it to the side and clicking the trigger, which lets us know the safety wasn't on. You can't click the trigger if the safety's on. Those two things, to anyone in that room, is a representation that, especially when and then he hands it back to Gearhart, it's a representation that this thing's safe. And the reason that's dangerous in this context is because no one else in that room knows what Defendant Shafer knew, which is that there's always 2 bullets in that gun. And there were 2 bullets in it that evening. You don't have to look very far to find out why this conduct creates a duty, how it fits within the common law rule articulated in Clark versus Dahlman. You can look to the National Shooting Sports Foundation and their firearm safety rules. They say very specifically, and this is their instruction, from the time you pick up a firearm, you become part of a system over which you have complete control. You are the only part of the system that can make a gun safe or unsafe. That is essentially the common law duty expressed in the context of firearms that this court has affirmed as far back as Clark versus Dahlman and as recently as other cases such as Hill versus Sears. So that's the context, the factual context of what happened here. This, in my mind, is an ordinary negligence case, and those 2 elements are the key, the demonstration and the knowledge. That is what the Court of Appeals held in this case. The Court of Appeals concluded that it was an ordinary negligence case. They rejected the notion that it was a premises case, and I think rightfully so. And they concluded that
Why do you think
reasonable
it's not a
jurors-
premises case?
I'm sorry?
Why do you not think it's a premises case?
Oh, I think it's actually simpler than we've made it in many ways. The case was filed, it's true, the case was filed both as an ordinary negligence case and a premises liability case. That's because the case was filed against not just Anthony Shafer, who didn't own this home, didn't own the gun ostensibly.
Why do you recede from arguing that it's a premises case?
Pardon me?
Why do you step back from arguing that it's a premises case, then?
Why do I step back? Well, I think if I were to argue it as a premises case, the defense would stand up and say, well, he's not the possessor of land, doesn't have possession and control, you don't have a premises case. If I was able to make an argument that she's an invitee on the premises, which she isn't.
Okay.
So that's why I think premises versus ordinary neg is an easy question for the court to resolve. We don't need to go into the questions of dangerous condition, instrumentality versus, and all those questions that have been addressed in briefing, because it's simply not. The only remaining defendant in this case is not the possessor of land, not in control of the premises. So it's not a premises case.
And you pled it as a negligence case and a premises case
Correct.
originally.
Correct. There were basically similar allegations in the complaint against all three defendants. I think the court knows, but the homeowners were dismissed, and that was not appealed. So they are out of the case, and that's why there's really no overlap.
Counsel, it doesn't sound to me like you're embracing the Court of Appeals special relationship framework. It sounds like you're saying something different, that
I don't disagree with that conclusion. I think the court expressed it as an alternative. Before they reached that discussion of special relationship, they found that there was an ordinary duty to use ordinary care, that it was an ordinary negligence claim, and that reasonable jurors could conclude that there was a breach. They then went on to say, and alternatively, we find that there's a special relationship given the context of this particular event. I think the reason they did that is because the defense had argued, and has argued here today, that this is a third-party criminal act. This is, of course, one of the questions that the court has asked in the leave order, that this is a third-party criminal act. Every case that the defense cites, all right, maybe I should qualify that. Every published case that the defense cites deals with an intentional criminal act. They don't deal with a negligent criminal act. Defendant has cited this one case, Coulihan versus Stamper, which is an unpublished Court of Appeals opinion, in which they're ostensibly on the facts, it appears to be a negligence type case, not that dissimilar from this. But what they disregard is the fact that the claim in that case was brought as a premises case against the owners of the property who weren't even there when all this happened. It was just a very different context, completely different context. I think the analysis was wrong in Coulihan versus Stamper. It is unpublished, it really has no weight here, and I don't think it's particularly analogous. But if you set aside that one unpublished case, and you look at Lolito versus Monroe, which is discussed heavily in both of the briefing, you look at those cases, every one of them, you're talking about an intentional criminal act that the defendant can't foresee, and therefore there's no duty. And that's the appropriate rule, because it's the deviant nature of an intentional criminal act that takes it out of consideration, that extinguishes the duty, unless there's a special relationship, which can actually overcome that. The Court of Appeals, I think, in analyzing the case and throwing out this alternative, they were really getting to the issue of, well, defense has cited these cases dealing with third-party criminal acts. Let's go to special relationship. We find that there is one, because there's some compelling facts. Justice Martin alluded to some of the facts that make you think that there may be special relationship here.
But it sounds...
They didn't need to go there, frankly.
It sounds like you would rather have this court write an opinion based on ordinary negligence. And your claim would be that the demonstration that the gun was safe, that affirmative act, plus his knowledge that there were 2 shots in the chamber, that's sufficient for your case.
I think that's the clearest route and frankly, I don't know if the court needs to write an opinion saying that, because the Court of Appeals said it. They just happen to go on and say this alternative basis of special relationship. But it's an unpublished opinion. I mean, we see a lot of unpublished opinions. The court could very easily, and if I hopefully successfully answer all your questions, could conclude that leave was improvidently granted in this case, because the essential holding of the Court of Appeals was that it's an ordinary negligence case, and that reasonable jurors could believe that there was a breach given these circumstances. There's not a lot of discussion. I've given more discussion to the particular facts of the case, but the holding itself is correct.
But we have to agree with you that there was an affirmative act on the part of the defendant, that this inspection of the gun to make sure it was safe is an important part of your theory of duty here, right?
Absolutely. It absolutely is. Because I think if the gun had sat in...
So he would have been better off not checking, seeing if it was safe?
In some ways that's probably true. But that's quite often,
right?
well, that's quite often how negligence happens, though, is that someone will do something thinking they're doing, but they don't do it quite adequately.
No good deed goes unpunished.
Yeah.
What's that?
No good deed
There
goes
you go,
unpunished.
there you go. I think, but this, of course, in the context of this case, I have a hard time
So do we
viewing
also
him
have
as a
to,
good actor, but
for you to succeed on this theory, do we also have to find that the boyfriend, that Gerhardt was moving the gun when he fired it because he thought it was safe to handle, and not that he was a little bit drunk and, recklessly sort of playing around with how do I get the shell to the chamber that?
in my mind, there's really no question based on what Gerhardt said to Shafer and what Shafer has related, he said, in two different sections of the deposition, he said the same thing. And that's why I described what happened here. I really don't think there's any dispute that what happened here is that Gerhardt picked up this weapon and, thinking there were no bullets in the weapon at all, racked it, which is, it's a pump-action shotgun. If you're going to play with a pump-action shotgun, you're going to rack it, which puts the bullet into the chamber, and then the mistake he makes is that he tries to pump it a second time, and he can't. Remember,
Yeah,
it's
but you
pist-
can,
it's a-
unless this is an unusual shotgun, racking it would eject the shell in the chamber.
Firing it would.
No, you can
Racking
empty
it
it.
only ejects the spent shell,
Oh, okay,
Yeah,
okay.
yeah.
and it's not a bullet, it's a shell, but,
But, and I think it's important that it is a pistol grip shotgun, because you think about it, he's got,
So there's no stock on this one?
there is, it has an extended barrel on it. I have a picture of the.
No, it's okay.
of the
It's
weapon.
like a grip then.
It is a shotgun.
But not a regular,
It is a shotgun modified so that it has
is
a
a
pistol
pistol.
grip.
Okay, gotcha.
And with a pistol grip, if you put your finger on the trigger and you're racking with your other arm, you're
Gotcha.
putting pressure to rack it. The slightest touch to that trigger can discharge it. That's why they tell you not to put your finger on the trigger when you're holding the weapon until you're
Counsel,
aiming.
was there any time that the defendant gave a warning about the weapon, or said not to use the weapon or not to handle the weapon?
No.
And was there any time that, would it be argument that, he gave tacit approval to handling the weapon?
I think he did through handing it back to him. He did the right thing in taking it from him to check, and then he proceeded to throw all that good deed away by handing it back to him, knowing there's 2 bullets in that gun, and all you have to do is rack it, and it's live.
And when he gave it back to them, he didn't give any type of implicit warning, or there was no further discussion? He just handed the weapon back to him with no other further explanation?
Correct. At least there was no testimony that anything else was said, and then Gerhardt, the eventual shooter, examines it and somehow holds it over his head. I don't really know what that was about, but that's what they say he did, and then he set it down.
So why isn't looking at the gun and making sure there's no shells in the chamber sufficient?
It's
I
not.
mean, and where is it? I mean, what he took some action, right? I think your theory is, if he didn't do anything, if he would have laughed and said, "Haha, it's funny, you picked up the gun and you just blew your own head off," then it's fine. But since he took the gun from him and looked at it to make sure he couldn't, without doing more, blow his head off, he also had to check the safety and eject the shells. And so where is it that we get the extent of this duty, that taking some action, he took some steps to make sure the gun was safe, right? You're just saying he didn't take enough steps.
I am saying that, and I'm saying that he effectively demonstrated to them, to everyone in the room, that this weapon is safe. By not telling them there's 2 bullets in it, all you have to do is rack it. And if I can address the issue of the safety.
I mean, this isn't a gun safety course, right? He's
It
not putting
isn't.
on this is what you need to do or don't do. While he's saying, he's looking at it and saying, okay, there's no
Immediate
shells.
threat.
Yeah.
It isn't, but I think
Without doing more,
the only issue with regard to duty, though, is really,
and he takes
did
it,
the harm become foreseeable at that point? Even if you analyze this under a premises rubric, which I don't think we need to do or should do in this case, what we're talking about would fit within premises and licensees and social guests, because there's a hidden danger here. He's the only one that knows that there's 2 bullets in that magazine.
but that's not unknowable. Right? Other people could find that out. Well, it's not information solely within his ambit of his being able to discover it,
Oh,
right?
certainly that's true, Your Honor. There's no question that Gerhardt could have taken additional steps. Gerhardt was defaulted in this case. He never defended. He went to prison on the negligent discharge claim. And I think it's important to note that if this case goes to a jury, fault can be apportioned to Gerhardt. A jury could very easily come in and say, we think he did the best he could, Shafer, and we really blame that guy. And plaintiff has no recovery.
Do you think there'd be a difference if the accident, negligence, recklessness, whatever had happened right when he handed it back, versus the 4 hours later when it's not clear to me that the defendant even knew that the victim and Gerhardt went back up to the barn?
To me, it doesn't make a difference because I think it's proximate enough in time, and it's an isolated group of people who, there's 4 people here, there's 4 people later. There is this gap in time, which the defendant makes much of, and there is them walking back to the garage without defendant and the other girl that was there. Frankly, the notion that it was unforeseeable they'd go back to their garage baffles me because I don't know where she was going to go. She didn't have a vehicle. None of them did except for the defendant. It would be a clearer case, but I think the test generally has been foreseeably identifiable persons that could be injured.
Well,
We've got a group of 4
Counsel, I have a
people.
question, though. Address the negligence argument and the foreseeability using Sister Counsel's analogy of the samurai sword versus a firearm. Is there a higher degree of care in terms of the fact that it's a firearm and not like a samurai sword?
I think the distinction between those 2 situations and why it's not an apt analogy is that guns are not tremendously complex, but there is some complexity to this weapon and how it operates. I think it's reflected throughout the record in this case, or even just in our back and forth about whether this is a loaded weapon or an unloaded weapon. There's more nuance to it than that. With a samurai sword, there's not really any nuance. I mean, you know what it is, and
Could be depending on how sharp it is.
it could be dull, I guess. With that caveat, and I think it's also important to note that in the United States, and we have 16,000 unintentional firearm injuries every year. I mean, this happens with stunning regularity. And now, I don't know how much that tells us for this case. I don't know how many samurai sword injuries there are. The CDC didn't tell
I guess, Counsel, my question was, is there a heightened duty of care due to the fact that it's a gun and not something else?
Well, certainly cases have talked about guns being instrumentalities that have an element of danger involved with them. But I don't know of a case saying that a defendant in this situation using a firearm is held to something higher than a duty of due care. I haven't seen that case. I think if I did, I would be citing it. but I don't think it's necessary here. I think it's pretty clear through his demonstration and his knowledge that we have at least a case that goes, a jury submissible case on due care. If I could say one thing about the safety.
Can I interrupt you for 1 sec? Can I interrupt
Yes.
you, please, for 1 second? In looking to whether or not a duty exists in a circumstance such as this, we tend to look at a balancing or engage in a balancing of the social costs and benefits. I think that's an explicit part of our duty analysis. So I guess my question to you is, in trying to assess the social costs versus the social burdens, what exactly would the law of this case be if you were to prevail? That is, what would you characterize as being the specific burdens being placed upon somebody in this case where he or she is in the possession of something dangerous, whether it's a samurai sword or a gun? What specifically would be the burden of somebody in the circumstance such as we have here? Do they have to render it inoperable? I don't know how you do that with the samurai sword, but do you have to render it inoperable? Do you have to segregate it from people? Do you have to put a big sign on it saying potentially dangerous?
Yeah.
What are the social costs or burdens that would be part of your analysis here? What is the law of the case that would emerge from an opinion by this court in your judgment? What should be the law of the case that would emerge from this court?
Well, I don't know that because of the unique factual scenario in which this occurs, that a lot could be read into it, other than an affirmation of the common law duty that already exists, and an application of it to,
Let me
I'm
just,
sorry,
you've just sort of narrowed this down to your case.
yeah.
And hopefully, if we've selected your case, it has implications beyond your case. Otherwise, it's error correction, something probably that we should not have had. So are you saying that there isn't any generalizable legal principle that should come out of this case?
I don't think there's anything new for the court to say here that hasn't been said in any number of cases dealing with ordinary negligence, other than an application of it to the firearms context. And really, when I said that what the National Shooting Foundation says.
I thought the real
Yeah,
oddity
every time
here-
you pick up a firearm,
okay, every time you pick up a firearm, what?
every time you pick up a firearm, you become part of a system over which you have complete control. You're the only part of the system that can make a gun safe or unsafe.
That's
That-
the legal principle?
That is an application of what the court has already said in Clark versus Dahlman and any other number of cases about the common law duty, engaging in an undertaking, creating a common law duty. It's an application of it to the specific facts of this case. I don't know that the court needs to delve into that area and make that, and that's why I said in response to.
I thought the singular interesting part of this was the Court of Appeals creation of a special relationship here.
I think that may well be why we're here. That
You don't
alter-
think that is necessary to the resolution of the case?
I don't think it is. I don't think it is, and maybe that does mean that we're in an error crash situation. I suggested to Justice Larson that an order saying leave was improperly granted would not be that surprising in this case, although the court may want to illuminate us on.
Do you
how
want
this-
to defend the special relationship of the analysis of the Court of Appeals, or are you sort of disavowing that and walking away?
No, I'm not disavowing it. I'm not disavowing it. I wouldn't want to give that impression. I think if I had to go there, it might have been the argument that I would make in this case. And it would have gotten me back to the same spot. It would have gotten me back to having a duty to use ordinary care. I think the reasons articulated in the Court of Appeals opinion for finding a special relationship in these factual circumstances, they are what they are, and I think it's valid, and some justices on this court may agree with it. But I think I have to be square with you that I don't think you need to go there, and if other justices view it as an expansion of the law in some way, if that's why we're here, then I don't think it's necessary to my case.
I guess I want to follow up on the question I asked before, and I think Justice Markman tried to ask, and even Justice Young, but once the defendant picks up the gun, what's the duty? The duty is to, you just read from the manual, to make the gun safe?
Yeah,
An
well,
absolute
there's
duty?
the array of options available to him, there's an array of options, including, I haven't discussed the safety, I've been trying to get to that, but that is one.
But let's talk generically, just what's the duty? Is it to make the gun safe?
Make the gun safe. And there's any number of ways he could have done that. He could take it out of the room, he could, store it, this is why we.
Had he placed it on the safety on, and his brother had taken the safety off, would he be still responsible for the injury?
If his brother took if he had
Cousin.
put it on
Yeah.
and the brother took it off,
Right.
I think it'd be a much tougher case.
Much
Maybe
tougher case?
I would probably be arguing special relationship a lot harder. And
How's
and
the
fighting
safety
with
different
foreseeability.
than making sure there was no chambered round?
How was that different?
Putting
Yeah.
a safety on is another step, but making sure there's no chambered shell is a step to making the gun
Well,
safe.
In the context of how this accident happened, and I think it's a reasonably fair inference to make that Gerhard didn't know what he was doing, or he wouldn't have tried to pump the weapon twice.
Okay.
I think that's fair. If Gerhard takes the safety off, we have a general sense of why a safety's on, and and taking it off has significance. So I think it is a very different situation if he does that. I don't know that that case is a loser for the plaintiff. I don't know that it is, but it's a very different case.
Unless you
I-
disassemble it, would be, I guess.
What's that?
I just want to be clear
Yeah.
in your position. If he had never picked up the gun, he's liable or he's not liable?
You
So the
have
gun's
to-
there,
Have to argue special relationship in that context.
Okay.
And we would be debating whether that is a special relationship, whether that's an expansion of Michigan law.
Because he invited her onto his grandparents' home, property?
Who was invited?
If he does nothing with the gun,
Yeah.
and all we have is a party where he's invited guests to his grandparents' home, how does he become liable for
Well,
the?
it's a party where he supplied the alcohol to
Okay.
the persons there. Now, granted, the shooter has just turned 21 a few months before, so there are cases out there that are gonna say that's not enough. The familial relationship's not enough. It would have to focus on protecting the minor from harm, and that providing her alcohol made her less likely to protect herself from harm. And I think that's a tougher argument than if Gerhardt had been under 21, and if the shooter had been intoxicated. Well, he had been drinking, but if you were under 21 and had been drinking alcohol furnished by Shafer, I think that'd be a very different case. If I could just make my one point on the safety. With regard to the safety, it's very important to note that William Shafer, the owner of the gun, testified that he had used the weapon. He always put the safety on. When Shafer tests the weapon, looks in the chamber and clicks the trigger, he's able to click the trigger because the safety is not on. It's the only way he could do that. So the question becomes, did he take the safety off? And there's no indication that he put the safety on before he handed it to Gerhardt. So the significance of that is, even if demonstration and knowledge isn't enough, I think it is, but even if it isn't enough, there's the issue of the safety, which the grandfather said that he always kept it on. And yet, we know that it's off while Shafer's holding that gun before he hands it back.
So neither the fact that he returned the gun to where it had originally been, or the fact that Gerhardt later took the gun, modified the gun in some respect, and acted recklessly with it constitute intervening circumstances. Everything goes back to the beginning, and
Let me
everything in
clarify one thing factually, if I can. He didn't put it back. Shafer didn't put it back. He handed it to Gerhardt. And the only thing that Gerhardt did was he didn't modify it anyway. He didn't go get bullets and put them in. He pumped it. He did what people do with a pump-action shotgun, particularly if they think it's safe to play with. So I don't see how you can view that as one most.
He altered the status quo, though.
Pardon me?
He altered what had been the status quo ante.
In assessing it in terms of whether it's the one most immediate and efficient cause in this case, which is what it would need to have to be an intervening cause, I don't know how you get there with the actions that Shafer took.
Thank you very much.
Thank you.
I'd just like to follow up on a couple of things that Brother Counsel said. First of all, with respect to the safety, there's no indication that Shafer used the gun after the grandfather used the gun and he took the safety off, or that before Gerhardt picked it up, he took the safety off. There's no testimony, no evidence whatsoever that Shafer did any affirmative act to turn the safety off on the gun. With respect to the his brother counsel's argument with respect to he'd be better off not doing anything at all, I think that would be seemingly contrary to public policy and would discourage people from doing anything, taking any steps at all to make it safe. If you're going to say you would have no liability if he just let him pick up the gun and shoot everybody in the garage, he's better off to not touch it at all.
So counsel, how would you want us to write the opinion based on what you're arguing? How would you write the opinion to that effect? How would you distinguish that from this situation?
Well, I distinguish it from this situation because in this situation, he did not have a duty to the plaintiff to do anything else. Brother counsel's arguing he should have done more. I cited a case where, in hindsight, you can always say you should have done more. There's no statutes, there's nothing saying he had to take the safety off, unload the bullets, lock it up in a room. In fact, there's case law saying there's no duty to store and secure your gun. And he wasn't even the owner of the gun. So then how far does that go? Does anybody who's in a room and sees a potentially dangerous instrumentality, do they then
But
have?
counsel, under your public policy argument, isn't the result the same?
Is the result the same if what?
In terms of the analogy that you just gave, don't we wind up with the same result?
If he was to do nothing?
Versus what you just said, how would it affect public policy? I guess I want you to expand on your analogy from the public policy perspective. How would I write this opinion distinguishing from the analogy you just gave with the opinion that we'd have to write in terms of trying to reach a result? Wouldn't the result wind up being a similar result to what you just argued?
I don't think so, because I think his actions, what he did, were reasonable. I think, and comparison to him not doing anything at all and saying, we don't want you to do anything. If you see a dangerous weapon, just leave it alone and let anybody have at it. I think that's a completely different situation than for him actually taking a look at it and making sure that there were no bullets in the chamber.
But so in the other analogy you just gave, do you feel the court should hold differently?
Do I think that?
In the first analogy you just gave, should we rule differently as it pertains to that?
That they should have no duty to do anything?
No duty to do anything versus having a duty to do something. Are you arguing that there's a distinction between the two duties and that the outcome of the case should be differential based on those two duties?
No, I'm sorry if that's what I was saying. I was not saying that the outcome of the case should be different. I'm saying that he did not owe a duty, did not breach a duty, but to go to the extreme and say he breached a duty in this case, but had he not done anything at all, he would not have breached a duty. I guess that was the point I was trying to get across.
I get it, and I'll just ask this one last time. What's the difference?
The
in terms of
difference,
the outcome?
The difference, well, I guess he didn't owe a duty is what I'm saying, that in Brother Counsel's argument, he said he owed a duty and breached the duty. In my case, I'm saying he did not owe a duty at all.
Right, and I'm just going to end with, but you would want us to rule the same in both cases, right? You'd want the outcome of the case to be the same in both situations.
Either way, Shafer should not be liable.
Counsel, you would agree, wouldn't you, that once the defendant picked up the weapon to secure it, that he assumed some sort of a duty to secure the weapon in a non-negligent fashion, wouldn't you? In other words, if he picked up the gun to secure it and then accidentally shot someone else, we'd be in a different situation, right?
Well,
So there
yeah,
was
I would
some
say
duty to, when he undertook to secure the gun and handle the gun, to do so non-negligently.
Yeah, and I don't think that he did anything negligently in checking the gun. I'm not sure that he undertook a duty by doing that.
I mean, once he picked up the gun, he had some duty to not handle it in a negligent fashion. You'd
He had a
agree with
duty
that?
to not shoot anyone with it, in that manner, yes, I would say. He had a duty to not harm anyone by pointing it at them and pulling the trigger.
So your position would be then that even if he assumed some further duty to secure the weapon in a non-negligent way, he didn't breach that
He
duty?
did not breach that duty. And also to get to one of the justice's arguments with respect to the intervening superseding cause, I think that is a great point in this case. This happened hours later, and Gearhart had to take affirmative acts hours after he set the gun back down in order for this gun to fire. He had to pump the shotgun and pull the trigger or put pressure on the trigger in order for this injury to even occur. So I do think that this was an intervening superseding cause as well.
Thank you.
Thank you.
Case is submitted. We're in recess.